Hi, good morning to all, and thank you for joining us today. My name is Julia, and I'm a senior associate in the insolvency team in Veirano Advogados in Brazil. On behalf of Veirano Advogados, myself and Paulo Campana, partner in our insolvency team, welcome to our webinar on debt restructuring in Brazil in the wake of the pandemic. To discuss the challenges faced by creditors and the ongoing amendments to Brazilian law, we will be joined by Samuel Aguirre, a senior managing director at FTI Consulting in the corporate finance area, who is responsible for the Brazil operation since 2012. Prior to joining FTI Consulting in 2008, Sam was a partner at PricewaterhouseCoopers in Toronto in the corporate recovery area. We will also be joined by Natalia Lima, the CFO at Xerpay, a startup that launched Xerpay, the first salary on demand app in Brazil. Natalia has over 10 years of investment experience. Prior to joining Xerpay, Natalia was the first investment analyst in Latin America at the investment fund Pinco. There, she was responsible for the analysis of a portfolio of over 40 companies with investments over $15 billion. Natalia began her career at UBS EM Desk in New York. Recently, she collaborated on the reform of the Brazilian judicial restructuring law, currently in the National Congress. During the webinar today, and you may see the agenda now in your screen, we will cover the status of investment landscape in Brazil, view of Law 1397, which has passed in the Chamber of Deputies and is now in the Senate, and potential implications for creditors and investment trends in Brazil. Let me just remind you that we want this to be as interactive as possible. At any time during the webinar, please be encouraged to send us your questions at the Q&A feature at the side of your screen. Again, thank you for joining us, and I will turn over to Sam with our first question. Sam, on March 20, the Brazilian government decreed a public emergency. Social distancing measures and lockdowns were decreed in many states in Brazil. Currently, all non-essential businesses are closed or keep a very limited operation.
Thank you, Julia.
How are businesses dealing with
the
immediate cash flow problems in Brazil?
This recession, Julia, is very different than any other recession that we've seen. I think it's much more severe, and it's going to take longer to come out of the other end. It's a suspension of both, not only the demand itself, but also the supply side of things, which makes it even more, complicated. At the macro level, I think, the business activity is obviously coming down from, I think two big angles, which is one is the consumption at the household level. Unemployment is going up, so people are losing their incomes and they're buying less. And for those that have maintained their employment, I think they're saving more. That's certainly a trend that we're seeing right now in Europe, and it's probably going to go everywhere. The other big factor is the reduction in activity in the industrial sector in Brazil, which was historically already a weak sector, but right now, the reduction in activity and the effect on demand itself is going to make it very difficult. So this is going to be a prolonged, I think, in my view, recession. What people are doing and what businesses are doing, they're doing whatever they need to do to conserve cash, which is obviously they start off by, if they have no revenue, they lay off staff to begin with, or at least they send them in furlough. They try to sell assets. Difficult to sell assets today at a fair price, given that liquidity is low. Cut dividends, tap your lines of credit. I mean, you'll do whatever you need to do to get the relief from a cash perspective for a period of time. But these are only measures that take you so long, or so far, as long as the recovery comes back. There comes a point in the business where the liabilities come to crystallize at once. When people start juggling, or they have historically juggled several liabilities, either by factoring in their receivables or tapping lines of credit to be able to make it to the next quarter or to the next week, this is really coming to a halt, or at least it's becoming very critical for those. So what we're going to see is obviously a trend of certainly more bankruptcies in small and medium businesses, certainly. And the question will be how many more judicial reorganizations are going to take place in Brazil. We have a graph here on on the screen, and I think we just wanted to illustrate a couple things. At the far right, you're going to see this is really the punchline: is where is this going? Currently, we're sitting at LTM last 12 months judicial organizations in Brazil. We're sitting at 1,300 for a year, which was really a declining trend over the last 12 months, given that there was, I think, a sense that the reforms were taking place in the market, and there was some sort of optimism. If you compare it to the other periods before coming back to this one, if you look at the Dilma period, which was really the 15, 16, we had a significant recession, we had a big depreciation of the currency, and obviously that created a big jump in judicial reorganizations. And then even further back, if you go back to the 06, 07, 08 period, where the law had recently been enacted in 2005. So I think there's a component of adoption of the new law, which was still in its infancy, but you can see that the subprime or the Lehman Brothers really didn't have a significant effect in Brazil of that. So things are very different today, where we see the trend in corporate organizations is certainly going to be in excess of 2,000 in my view. The question will be, and I think we're going to be discussing this in the seminar, is really for people to enter into judicial organizations, there are several factors. It's not just the economy, it's the timing of your own businesses. Do you have a plan today? Do you have other options? Will these measures, give some relief to some extent and prolong, the ability to get some sort of a standstill?
Yeah, so in spite of the obvious distress
situation, assumptions have to be made in order to come up with those numbers. But I think
that most businesses are now facing, the number of bankruptcies in Brazil has not yet risen. What are your thoughts on that, Natalia, and then Paulo?
Sorry, I was on mute before. Hi, everyone. So I think, first of all, we were, as everywhere in the world, going through a bit of a wait-and-see mode. Right? We had a period where everyone wanted to understand the extent of the crisis, how far the pandemic would go, what that would entail. And then I think the second part of that is also trying to understand what are the tools that we can all work with, right? We have a period where you're still, companies are still negotiating with the banks and going through that process of understanding what government programs they can fit into, what the reaction of the banks and the other creditors will be, and then also what the law and the framework is going to be, right? And then I think the law that the new project that is going through, that went through the lower house and is going to Senate, is another point on that, which can provide some relief for, especially for the company, from the company perspective, and how that's going to impact their own negotiation. I think the graph that Sam just showed shows a lot of that, right? We're still in the very beginning of what we're really going to face.
Yeah.
Okay, so thank you. Yeah. Last Thursday, so last week, the Chamber of Deputies passed a Bill of Law 1397. which is intended to provide emergency and interim measures for companies under distress to deal with the economic crisis caused by COVID-19 pandemic. The Bill of Law has two chapters. It's a short Bill of Law. The first sets rules aimed at preventing insolvencies, whereas the second establishes interim changes to the current Brazilian bankruptcy law. Paulo, can you expand on the proposed measures to prevent insolvency?
Of an attachment of assets was not a factor that really compelled debtors to file for court protection. Yeah, of course. First of all, please note that this is not law enforcement we're talking about here. It still has to be approved by the Brazilian Senate. So it can still be amended before approval, but we expect it to be approved anytime soon. Said that, the bill provides for a new insolvency prevention system, which can be used by any economic agent, which is considered any independent professional, civil association, and company as well. Companies as well.
That they can't hear you.
Basically, any entity and professional can use this insolvency prevention system. Right. Consumers are not included. The first measure that the insolvency prevention system provides is a stay of 30 days following enactment and publication of the law. This 30-day stay, during this 30-day stay, obligations which were due after March 20 cannot be enforced. Also, companies are protected from bankruptcy filings and from involuntary bankruptcy filings, and also from enforcement of collateral and acceleration of agreements. I'll go first. Of course, of course. Is it better now? Okay, let's try then. Okay, as I was saying, this bill of law provides for a 30-day stay, which is applicable to any economic agent, basically everyone except for consumers, right? And during this stay, creditors cannot enforce their obligations which were due after March 20 against those companies. Also, companies and those other economic agents are protected from the commencement of bankruptcy filings and enforcement of collateral. Acceleration of agreements is also not allowed during this period. So basically, we're talking about a general stay here of 30 days. Labor claims are not included, so basically the company has is still bound to pay all labor debt during this period. Other than that, claims are basically included. Right. Agreements which were concluded or renegotiated after March 20 are not included by this date. So if a debtor renegotiates an agreement after March 20 or concludes a new agreement, this agreement can still be enforced after this law enters into effect, and it's not included in the 30-day stay. The purpose of this 30-day stay is to allow the debtor to renegotiate with its creditors. After the expiration of this 30 days, the debtor can still file in court for a brand new proceeding called preventive negotiation, which triggers another stay for a period of 90 days, counting from the date of filing. And during this period, the debtor has to renegotiate its claims with the creditors. In order to be eligible for this, the second stay, not the first stay is for everyone, but the second stay requires the debtor to submit evidence that its revenue declined 30% at least in relation to the same period of the previous year of 2019, right? So basically, this one is not for everyone, but for companies and individuals which really suffered the consequences of the COVID crisis, right? During this period, this 90-day period, creditors and debtors will renegotiate the debt, but there is no court mechanism to cram down dissenting minorities. Creditors and debtors either reach voluntary agreements or they did not. If, of course, the debtor is not able to reach an agreement with its creditors, it can still file for a court proceeding, either a judicial reorganization, an RJ, or a pre-PAC, an EJ, right? This 90-day period cannot be extended. Any request for extension will be considered as an RJ filing. Right.
The measures to prevent insolvency, notably the 30-day stay and the preventive negotiation, aim at incentivizing debtors and creditors to negotiate and settle out of court. We also know that some courts in Brazil have a significant backlog. Some argue that an exponential increase in insolvency proceedings could cause the system to collapse. Natalia and Sam, what are
the original claim goes back to
your thoughts on that? Do you think that if the bill passes, it can provide unexpected and needed relief? What are, in your view, the main challenges and or positive aspects from a creditor's perspective?
How this procedure works.
You want to start then? Okay, I'll start then. Well, I think first of all, the automatic 30-day stay is an interesting relief, as it is an all-encompassing, indiscriminated relief for everyone. But it is a bit concerning that it becomes a bit of a free-for-all, right? It becomes, as I understand it, a 30-day period where no one really has to meet their obligations. Or why would you, right? But we understand it is a time where you give the court some extra time to organize and so on. The preventive negotiation is a really good and I think interesting concept, a concept even that should be promoted in the more permanent law and not only the temporary discussion that we're having today. And as it incentivizes all the parties to sit down and try and negotiate before filing. That should be happening already in the first place, but as we understand, it is a good relief that to give the companies. The part where I find really interesting is the part, well, one, you do have some sense opposite to the 30-day, which is really just a general relief that you're giving everyone. The 90-day preventive negotiation, as I understand it, is only applicable to companies that prove that they had a 30% decrease in their revenues in the period, which I also find interesting, except for the part where it's going to be, it is a little, it hasn't been too well specified in the law how you're going to prove that and how to discuss that, right? But you're affording the company a bit more time, And the part that is also really good is that you're giving priority new money to the new money where they would not participate in further in a post filing, right? I think that part is really interesting. It promotes the new investments. It's something that has always been a challenge in Brazil, and it has its flaws, but it's probably in the best format that we could actually find. The part where I find to be really challenging is the part where we talk about clawbacks, or I guess we could call them clawbacks, if there were a filing in the next 1 year. I think that was a measure that was probably put in there to protect creditors, to prevent a company from going into a 90-day negotiation and then finding good results and then filing later on. But in reality, it just inserts so much uncertainty that it really makes it hard to deal with. And I'll stop here. I'll just make one more comment and pass it on to Sam, so I don't spend the whole time talking. But in general, I would say that's the biggest challenge that we have in Brazil, is just the rules of the games that keep changing, right? And that makes it really, really hard to operate, because you're basically operating in the dark. You just don't know what's going to happen next.
Thank you. Let me just complement that on the 4 points. The 30-day stay, it provides, I think, in practical terms, good but very little relief to companies. So it forces them into this preventive negotiation automatically. So, and that's really the goal. The goal is to push them into some sort of a negotiation with their creditors. On the preventive negotiation itself, I think the biggest flaw, and I think you alluded to that, Natalia, is to some extent, if this is ultimately, a deal that it may not be or will not be sanctioned by the court itself and could be reverted, I think, the objective actually may not be achieved in the first place. It really comes down to, today you have bilateral negotiations between companies and creditors before filing, but to the extent that you reach an agreement today, your agreement should hold, if there is an RJ, if you extend terms or if you get new collateral. Obviously, we're not talking about new money in this case, but we're talking just about normal, a potential roll-up or any other kind of structure that, would allow you to get a bit more collateral. In this scenario here, with the amendments, this is not possible, which I think cuts some of the incentives for creditors to cut their deals soon in the game. They're going to wait to see how this goes and understand whether it makes sense to put the efforts into, having a negotiation, bringing the professionals, if that's the case, or the lawyers to document new structures, when in fact this could all be reverted if there's an RJ. And maybe not because the debtor changes or retrades its mind, but potentially because holdouts are not, at the table and use that leverage to try to derail the process. So I think there's going to be some holdback from creditors to understand exactly how these negotiations go, and that may be a reason why this doesn't, go as planned. In fact, I think what this measure is doing is in a way flattening the curve in terms of, processes going through the judicial system. That's exactly what's going on, right? I think we don't want to see the second half of 2020 with a significant curve in the courts where everything is clogged. In fact, you want to put that over a period of time. I think whether it's going to happen, it's not the question, is when it's going to happen, I think, and that's what we're trying. I think that's what the government's trying to do, is to prolong this. As to the creditors who are offering new money, I think they're also going to be holding back to some extent. Even though they're going to be protected, they're also going to be looking at whether this is going to be an RJ or not, because the type of collateral that they get will be treated differently in an RJ or outside of an RJ, even if they have a first priority. If it's an essential good, or if it's a good that's deemed to be essential, so that's the same thing, essential by the business, or a good that can actually be enforceable on a practical basis. They're going to be looking at all these variables before actually giving the new money, if this is going to potentially go into an RJ. So I think for a number of reasons,
Thank you, Sam.
It's a good measure to flatten the
Thank
curve,
you.
but I wonder whether
Paulo,
in
from
practice,
a practical perspective, the risk of transactions being unwound, so transactions that you execute during the negotiation, the preventive negotiation, the risk of it being unwound during the reorganization or return to the status quo. Do you think that beats the purposes of the Bill of Law? So to the extent that the Bill of Law aims at incentivizing creditors to and debtors to settle out of court?
It doesn't really, unwind. I would say yes and no. First, because there is no protection against clawbacks. So if you provide new collateral to creditors, there is a risk that this new collateral is
so moving on to the interim changes to the current Brazilian bankruptcy
by
law.
other creditors
There are the bill
is already on the verge of insolvency, so there is this risk.
Proposes relevant changes to the pre-pack and judicial reorganization proceeding.
Get a new one.
Can you please comment on the changes to the pre-pack or extrajudicial reorganization?
So it's a risk that the Bill of Law does not address. But if you look at the case of smaller companies which are only going to just renegotiate the debt without creating any new security interest at the benefit of creditors, then does not affect them, right? But for more structured renegotiations and restructurings, this is a point that creditors should look at more carefully, right? Yes, of course. Current Brazilian law provides that a pre-pack must be filed in court only when the debtor has approval of holders of 60% of the affected claims, right? This is what current law says. What the Bill of Law proposes is that the threshold is reduced to 50% instead of 60%, so it makes it easier to reach the approval requirements for an EJ plan. And also it provides that the debtor can file an EJ when it has reached 1/3 of the claims. Basically half of what we have now. If the debtor has the agreement of holders of 1/3 of the claims, it can file an EJ plan, and then the debtor will have 90 days to collect the remaining signatures, so it will have the full 50% of
folks
approval.
Still complaining
right?
about
so
the connection. I think your sound is breaking up a little bit, and your image.
The thresholds are lower.
So I understand you were explaining to us a little bit about the lower thresholds to approve a pre-pack
from the Bill of Law. We had in the
plan of organization in comparison with the current the law currently in
could
effect.
affect labor creditors.
And
it's not anymore in the Bill of Law.
Standstill period
right?
to get the approval.
It would have been a major change.
Approval of the majority of creditors, as long as debtors have a support of at least 1/3 of creditors. So those are very interesting features and can help make the pre-pack more interesting for
I think they're very good news, because the EG is a tool that I think is you know, as practical as it should be, it's really not used, at least to the extent that, you know, people wish. So I think these are effective changes. The biggest flaw has always been that the labor and taxes of not being able to, or were not included in there, and it makes it difficult to implement that when you have, you know, large groups of creditors outside of these potential plans. So I think that's good. The opportunity to, you know, to have a lower quorum is always easier, obviously, for a company to be able to, you know, to implement whatever they want, and the ability to start off with 1/3 and then work towards, you know, a 50%, which is already a lower threshold, is a very good news, and it allows you to drag a bunch of holdouts in the process, you know, and to the extent that you can achieve that, then it could be a really effective tool. So I wonder whether this is something that, you know, will go beyond just an interim measure, but will become a more permanent measure, because you really need to give a boost to this implementation tool to make it work. Pre-pack should have, you know, a much bigger, you know, level of activity than RJs.
Yeah,
they're simpler, they're faster, they're more economical.
I agree, Sam.
So
Paulo, you're back. Hopefully the connection works a little bit better now. The Bill of Law also provides for significant changes for debtors who are already in JR proceedings, in reorganization proceedings. Could you provide an overview?
Yes, of course. I hope the connection is better now. I hope you can all hear me better now. Yeah, the Bill of Law provides for some changes to the already existing rules. But these changes will only be effective until the end of the year, so they will lose effect on December 31st if the bill gets approved at all. So it's just temporary measures which are not definitive, and they will expire at the end of the year. Still, they may be very relevant. In the already existing RJ and EJ proceedings, which there is already a plan being renegotiated or approved, there will be a new stay of 120 days. It's a new stay for the companies which are already under reorganization. And during this period, the debtor can propose a new EJ or RJ plan. So there's basically as if they had filed again for a new reorganization proceeding. And this new RJ or EJ plan, what it can do, it can affect, it can impair all the post-filing claims. That's a new one here, because as you know, when you file for EJ or RJ, only pre-filing claims can be affected. But now, if the bill of law is approved, the company already in EJ or RJ
120 days stay for companies under RJ to amend the plan, and they can also impair post-petition claims. So that's an interesting feature for the debtor. Natalia, even though the bill of law may still change and is yet to be voted at the Senate, do you expect this?
They will be not affected by the plan, provided that the creditor had previous court authorization to extend the loan.
Yeah, I think I alluded to that a little bit in my previous comment, and
to the new plan. So that's
I
big
think
news.
this is serious, right?
It changes the rule of the games in the middle of the game.
I always have a tough time with the debate around the judicial restructuring law, because I never understood too well how the companies put themselves in a position to try to defend their interests and make them more and create a law that is more pro-debtor than pro-creditor. But in reality, that law has proven to be so ineffective, and having a framework that is so ineffective has shown to be so costly for companies. Right? This is the reality of the Brazilian framework that we have today. And I think that especially this part of the law about the pre-existing bankruptcies, that is probably where we have the most issues and where we can really insert all the more uncertainty in Brazil. So yeah, absolutely. I think that could affect investments. I think that it is all the more relevant right now, and it is going to become increasingly more relevant as we are faced with a world with so many challenges to investments across the world, and we find Brazil with a framework of more uncertainty. Don't get me wrong. I understand that we do need some form of framework that is temporary, that provides relief, that can that can improve dialogue and can improve negotiations, and even that can protect some of the positions of the companies. But that framework cannot bring more uncertainty, and it can't change the rules of the game in the middle of the game, right? That is the part that we have serious issues with. And I really would, the part where I really could preach to companies and to judges and to all the participants, all the stakeholders in the bankruptcy or a credit framework overall, is to say having a pro-debtor framework is really not necessarily what brings you the lowest cost, is not really what protects you, right? Having a good framework, like we see, for example, in the U.S., where there is.
Natalia and Sam, same question. Can such changes affect investors' appetite and liquidity in the in the secondary market? And what are the prospects for the post-pandemic environment in Brazil? In China, the businesses are reopening, but according to reports by The Economist and Bloomberg, the new normal looks very different than before. How will companies in Brazil deal with the new environment in your experience?
Thanks, Julia. Look, it's really a tough question because it depends on the assumptions that you put in your model, the assumptions that I put in my model. Everybody has a different view as to what this means in the speed of the recovery itself. And different sectors will recover at different speeds given, their ability to go to market sooner than later. I do believe that on one hand, on the secondary market, the ability to, for companies either to get, either be able to do buybacks or lenders to be able to sell their loans or these sort of things. I think it's going to be more difficult in the next few months simply because I think distressed funds have, frankly, better things to do than going into highly liquid assets in Brazil specifically, which has, right now we have significant, insolvency risk, political risk. We have a number of factors which makes it difficult for distressed people in the secondary market to come and invest, I think, in large sums of money. It doesn't mean it's going to be forever, but I think we have a situation in the next 12 months or 16 months where it's going to be difficult. The second point, I think, is Natalia's point, which I wholeheartedly agree with that. The law is ineffective. I think, what we should see at the end of the tunnel here is the companies that were healthy are on their way to be healthier, to be, sort of benefiting the most from this interim measures. I think the real error, or at least or the mistake that could be made is actually dragging a number of other companies, which I don't know, I call them zombie companies that were sort of struggling to get by, and now they're going to get a boost and they're going to come out of the other end, trying still to to come by with the same problems that they ever have. You don't have this rejuvenation or or recreation of new companies and make it more competitive. I think it's a little ideal in an ideal world, but I think that Brazil needs something to that effect to be able to to create jobs. In fact, you need to create competitiveness. You need to create sectors that actually can compete against each other. And right now, I think it's difficult to say that is the case. So, and the bigger question is are the RJ process going to become even more dynamic or more uncertain, or are we going to have some stability at some point where we know that the rulings are X and not X, Y, and Z? I think that's the bigger problem for investors. I mean, coming in, not only for secondary investors, for everybody that is going to go, especially in the interior where you have different rulings, for example, where are you going to come out? It's a little difficult for, especially for foreign lenders. I think they're not equity holders, they're lenders, and they're going to come out and lend to companies in the interior. And if they see that,
thank you, Sam. So predictability, very important,
how do you plan
especially in this situation.
The decisions could be,
we have some questions from our audience. So Bruno asked, how long do you think it will take us to be close to the American bankruptcy law?
But there's got to be some
sometimes I think that many companies go into bankruptcy because of the Brazilian laws, and how can we improve that? I'll turn over to Paulo.
Well, I think this question may have many answers, right? It is a good one. I hope you can hear me better now. Well, basically, when you look at the bankruptcy law, we think how long it will take to get for each.
If I can add a little bit more, I'd say it would take a generation.
If you look at legislative history,
I think
what we see is that
we are
Brazilian bankruptcy
we've seen positive developments in that front.
Some problems, some challenges which were faced back
and even the bill that was being discussed
in the 40s,
as a new bill, not this temporary bill that Paulo and I even collaborated a little bit on.
One thing that we should take
it was a positive development, right? But if I
2005 law, we had
if I could say something a bit, controversial here, is that we still don't have even the mentality to improve the framework to a U.S. level, right? The moment.
And this,
we have such little assurances or certainty that the framework is going to work, that we have the banks, for example, and this is probably the most controversial thing I would say, but the banks wanting to be outside of this process.
There is still,
right? Even as we're talking about the full evolution or the permanent evolution and development of this law, the banks as creditors, the biggest thing that they're trying to do is to keep the fiduciary liens outside of bankruptcy and take themselves out of the process. Right? This kind of shows how little how little certainty we see in the framework, even as it improves.
We can learn from what they.
So I think it would take a generation. I think it would take a change of mentality of the legislative, but also of the judiciary system. But we're definitely, the good news is
Let me add something to Natalia. I think the generation is right in my view. The Latin American countries sort of have similar insolvency laws where they're debtor friendly. I think the culture makes it more important to give families or owners as opposed to in the U.S. where they're professional managers. So I think there are real cultural differences as to how you approach the law itself, and that's going to take a long time. The second thing, it took the Americans 30 years to get, Chapter 11 where it is. So even for them, it wasn't easy. So for Brazilians or for other Latin American countries, it's going to be very difficult. But I think there has to be.
Wrapping up, we will not have time to go over all the questions, and thank you for sending
one of them is insolvency.
Those questions. We are available.
Is something we haven't discussed, but that's fundamental. If you cannot bankrupt companies, then they keep on living.
We'll leave our emails and you can contact us directly.
We
have one more question from
So I think there's not necessarily simple things, but there are big decisions that need to be made at some point by
who let us know that he has clients with over 400 million debt to restructure, but the process would only be a success if large Brazilian state-controlled banks and other relevant creditors put new money in the company. And he asked about the legal path and steps for the company under the circumstances. I think that's a good question to wrap up, because a debtor in that situation could resort to the to the type of legal instruments that the Bill of Law is proposing. So first the 30-day stay, then the preventive negotiation that lasts for 60 days for creditors and debtors to negotiate, and allows for new money, allows for protections and for the new money. And after that, the debtor could resort to an out-of-court reorganization, the pre-PAC, Brazilian pre-PAC, or the judicial reorganization. Do you have any additional comments on that? Do you think that the investment will come from the large banks, the new money will come from distressed funds? How do you think that will play out, and in this new potential environment that we will see in terms of steps for debtors and this large Yeah, thank you. And the last question, are there reasons the debtor would skip the 30-day stay and or the 90-day negotiation period and immediately initiate a bankruptcy proceeding? And I think it's along the lines of what you just answered, right? It depends a lot on the features and the debt profile and what collateral are you willing to give and what collateral creditors are willing to take. There are some risks in the 30-day stay or the 90-day negotiation that you don't
in which it is sometimes it may be
have the protections that an RJ proceeding would have for creditors lending new money, for instance, or
not
structuring collateral, but the bill of
but even now, what the banks and the creditors can discuss is whether it makes sense for the company to file for an RJ, so the loan will be more protected.
Labor debt of strictly wages, strictly wages, not indemnities or you were agree with you, Paulo. But I think the point is the Bill of Law incentivizes companies to resort to the 30-day stay and the 90-day negotiation. So I agree with the audience that you have a lot of incentives to go through all of these steps before resorting to a
it really depends on the situation.
JR or
the risks should be addressed.
So
right,
we are wrapping up. I don't know if you guys have any last comments, Natalia and Sam. Do you have any last comments? So, we are almost
and they don't provide enough
on time
for creditors to extend additional money to the company, and that's a challenge we'll face in the coming years.
Thank you very much. Thank you all for joining us today, and